Hello, good afternoon and welcome to today's webinar. My name is Harriet Swainson. I'm a partner at gunnercooke and you are listening to a webinar on bespoke real estate recovery for building societies, specifically how to recover your secured debt more easily and more quickly. I'm very conscious that most listeners don't know me or probably gunnercooke. So before we get into the webinar, just very briefly, I'll tell you a little bit about us both. The firm is the fastest growing challenger law firm in the country. All partners are noted experts in their respective specialisms, and almost all have joined from national and international firms. Most people have joined gunnercooke for the flexible working opportunities it provides, and in my case I joined the firm following the arrival of my two children and my desire to continue working at the level I previously had, but also have the flexibility to be at home as much as possible. I have to say, so far so good. I now have the pleasure of working with the clients I choose and doing the work I enjoy the most. And what's more, I can spend 100% of my time focusing on my clients. We're all self-employed as partners, so our clients are our only driver. Professionally, I have over 12 years experience of niche real estate recovery work, working at all levels of debt and volume, widest possible client base, from international private equity houses to private individuals, from high street banks to bridging financiers. I also spent quite a considerable number of months on secondment, both as a relationship manager at a high street bank and also as a legal advisor. Almost all of my clients now are building societies. That's mainly because you're the people I enjoy working most with. You're the people I feel I can add the most value to, and that's the reason for doing this webinar, to reach out to more of you and hopefully work with some more of you going forward. Now, before we go any further, today is the 2nd of August. Aside from being National Child's Play Day, it's also National Ice Cream Sandwich Day. Slightly more obscure, so hopefully slightly more memorable. At some point during the presentation, you'll see this slide again. And if you make a note of the point in which the slide appears, pop that on an email to me, then all correct answers will get some form of ice cream, hopefully when we start working together. If you have any questions during the webinar, pop them on an email to me and I can respond individually to you. The reason for not doing it as we go along is that I want to get through the content of the webinar in the time that I've said we'll be talking for. So let's get into the webinar. RAID. Nothing to do with bug spray or computer storage. It's a simple acronym which I think is really useful in order to ensure the best recovery outcome is achieved for all the parties involved. It's also what is often considered a standard process. It's what enables that to be tailored to an organisation type or even a specific lender. First of all, you review your position. Let's move on to the next slide and you can see them. Review your position. Then you can consider your approach to the borrower. You can also then look to see if there's anything you can do to improve your position, and only then consider whether, if you need a disposal, then the best way of achieving that. Over the years, I've worked with numerous building societies, and I've found there to be real differences in priorities and drivers when it comes to recovering debts. And that's part of the reason I've put this webinar together, because it's those differences which I feel have really enabled me to add financial value to those building society clients of mine, and something which on a personal level I've found much more fulfilling and rewarding. Now obviously every case is different, every case will be fact specific, each customer relationship will have different objectives, different things going on. However, what I hope to do in the next 30 minutes or so is provide you with an outline of the generic recovery steps that we would typically go through, but encapsulated with my building society experience and my practical thoughts on the best way of using your professional advisors. Now, please don't think this is in any way designed to upset any relationships you already have. It's only aimed to provide food for thought when you consider the best way of recovering your debts. So let's get into it. Review. So first of all, to do a review, you need to know what your legal position is, you need to know what your practical position is, and look at those options that they're giving you. Just working through very briefly, you can look at the slides if you want to, listen to what I'm saying. Obviously, the slides are there for you going forward if you want to keep them. In terms of the legals, anyone who's looking to recover a debt of any sort will need to do some basic steps. First of all, you need to check your security. Check it's held over the assets you think it's held over. Surprising how many times that's not the case. And also check it's held in the borrower or any personal guarantees in the guarantor's names. You need to check what can be recovered in terms of the security. So is it security which covers all debt due to the building society? Is there a restriction on the value of that security? Check the priority of the security. So are there any prior ranking charges or any prior ranking interests? Check whether there's anybody beneath you that might be looking to also reach a recovery or something like that. Check the asset itself if possible for its value, and then obviously take your advice from there. Now, often traditional law firms or typically smaller firms will offer to do security reviews for free or on a contingency basis of winning future work or because they already carry out a volume of work for you. Now, my advice specifically to building societies and those lenders who have a more bespoke lending policy is not to accept free security reviews, which might sound absolutely crazy. But free reviews, having worked in different firms, free reviews will almost always be carried out by very junior members of the team. And whilst they will have been trained very well to check the security position and even sometimes advise on how to dispose of any assets involved, whilst all of that is absolutely essential, it's only step one. And I think a lot of building societies are much more relationship driven, and often there can be other ways of working with the customer to obtain a satisfactory outcome to recovering a debt rather than necessarily disposing of the asset. One example I can give you is that we did a security review, and then based on the outcome of that, there were a few anomalies, and we worked with the borrower, and that borrower actually ended up having future lending because of the issues on that case. They weren't completely dead in the water as a borrower, and the building society did do future successful lending with them. I think also at this point in time, demonstrating to your customers that you are doing such a review, looking at all the angles, it demonstrates that you continue your unique and bespoke manner of the relationship, as well as giving real true value to the meaning of treating customers fairly. What I think is therefore required at this point in time is an experienced pair of eyes looking over all the documentation that you have to ensure that all recovery options are considered, looking at all the practical things that are going on, and bring all those to your attention. So, for example, getting the borrower to work with you to maximise recovery. Have a look to whether there are competing interests on the title that might hamper or indeed aid your recovery. Look at what level of the lend is and check that's in line with historic values of the property. There might be professional negligence concerns. There might be additional security in place. There might be insolvency situations going on. So all those types of things, they can all lead to a more satisfactory resolution to a potential problem. It can also be worth at this stage asking a property professional to take a quick look at the physical property and see if there's any practical issues which either might cause problems or again help you in your recovery. They can also do brief investigations and see whether there are any potential special buyers or special interested parties around any assets. I really do genuinely believe that a few £100s at this stage can potentially save thousands of pounds or a significant amount of time, or sometimes both. It's also worth bearing in mind that in most cases the cost of recovery can be added to the customer's debt if the building society so wishes to do so. Obviously you need to be careful if there's negative equity or if you're running short on equity, because they would obviously be costs that the building society would incur. So moving on to approach. Now again, I would repeat the sentiments that I made earlier about working with your customers. There's often softer ways of getting into a resolution, particularly if your advisors are involved early on when problems begin to occur and things don't seem to be quite right. No doubt before you even think about talking to a solicitor, you'll have sent initial letters to the customer, and conversations possibly will have been had with those customers that are facing difficulties. What I've found can have a real impact at this stage is having a conversation with a legal advisor, a solicitor. It can't be a conversation during which a solicitor advises the customer what to do. That would be a conflict of interest. But what it can be is someone formally setting out the society's position, highlighting the options it has available to it, and that really allows the society to demonstrate its desire to work with its customer. But at the same time, it clearly outlines the options that the building society has available to it, and it can create that buffer between building society and customer. Now, a couple of comments I've had in the past when I've made that suggestion from the building societies I've worked with have been, well, doesn't that seem a bit heavy-handed? I think if it's done the wrong way, yes, it can. But I genuinely think that giving the customer all of the information at the start of the process can be really helpful going forward. It enables the society to have a clear picture of how the borrower is approaching the situation, and that can be a call that everybody's involved in. And it also ensures that if it does look like the borrower isn't going to be cooperative or seems a little hostile, we can make sure at that point in time that all the correct questions are asked to get as much information from the customer about the asset, about what's going on with them, just to make sure that that recovery is as painless for everybody as it can be. Having the time and the ability to deal with each case on that sort of bespoke level is something which a lot of lenders don't have an opportunity to do. Either they have a remit to recover as much cash as they can, or the volume of cases just simply doesn't permit the amount of time. And again, that's one of the reasons I really like working with the building societies, because you don't have that same level of recoveries. Typically, you've had much more conservative lending, and I think you have the ability to get people involved and then do things on a much more bespoke level. So if we take things one step further from an initial phone call, if that doesn't work with a borrower, either because it doesn't give you guys a satisfactory response, or it just looks like the borrower doesn't want to engage in any kind of correspondence, then sometimes it's necessary to send out a letter to let you know that you're serious about recovery. That can and often is sent from the lender, the building society, and quite often it's amazing how many times I've worked with lenders who've got no response from numerous letters they've sent out, and then they get one letter from me which quite often will say very little different, but they get straight in touch. And I think it just really outlines that a sensible point of contact at that time can make a real difference. The borrower knows that you're serious about your position, and it can really reduce the time it takes to recover a debt, and often can recover more of a debt. The other reason it can be really important is what I've done over the years is just introduce a little box at the bottom of that letter to say, look, if you're not in a position to repay your debt, it's fine, we understand that. But if you can just make a note and sign to say that's your position and send that letter back to us, that's incredibly helpful. Going forward, it gives you real comfort that the borrower isn't going to turn around and suddenly come up with lots of options, because right at the start they've said, look, I just can't deal with this, or I don't have the means to refinance, for example, or I need this to be taken out of my hands. And so that's proven to be so incredibly helpful on lots of occasions. Now, I've put next on here settlement agreement. They're not something which typically building societies like to use, and I often think it's overlooked as a recovery option. Given building societies are typically more conservative in your lending, it's more common for there to be equity in an asset, which might make you think you should always go for a full recovery, but actually it might well be that your position is that you're happy to accept a slightly less amount than the full debt to recover it quickly, or it might be that you're happy to allow your borrower, knowing their position, to repay it a slightly smaller amount. And the settlement agreement is a fantastic way of making sure that everybody has a really protected position. Now, the responses I've had in the past when I've done settlement agreements initially are that, well, they're not deemed to be necessary on the basis that you can simply release your security that you hold over a secured asset when the debt's repaid. Whilst that's true, I think it's advisable to protect your position from any future claims that anyone else may have, either from other interested parties, or if there's any insolvency practitioners involved a bit further down the line. It means you've got no comeback on things like future claims for preferences or anything like that. An agreement, it doesn't need to be expensive. It can take a very simple form, and again, I think it's a cost which is really good at giving the building society just that little bit more protection. And again, it's a cost that can be added onto the debt, and for such a small amount, I think it's a really sensible way forward for both customer and the building society. Handing back of the keys, consensual sale, similar recovery ideas, but quite different. Often the option of handing back keys can be as a result of a gentle nudge and a conversation with the borrower, just to let the customer know that you're serious about recovering a debt. And one particular memory comes to mind when I worked with one society, and it was quite a difficult case in the sense there was lots of nuances involved, and a quick chat with the customer and a follow-up letter actually resulted in the customer sending a very polite letter into his relationship manager, enclosing the keys to his assets. And because the relationship ended on such good terms, that particular society did comment to me that they wouldn't rule out lending to that customer again in the future. It was an unfortunate set of circumstances that they'd found themselves in. But yeah, going forward, they would. So again, a really positive resolution to that. If there is equity in a property which a customer wants to maximise or protect, and they can't repay either all or some of their debt, then a consensual sale might be the next best thing. Often it's a really positive step for both society and customer in order to maintain both that community face of the society and avoid any potential unnecessary reduction in the debt and the value which can occur sometimes if it's known that either insolvency practitioners or receivers are involved. Legal and property professionals can also help maximise recovery in those sort of situations, because you can be involved but you can be behind the scenes, which leads me very nicely onto the third aspect of recovery, and that is to improve your situation. Now, this section is actually relatively short, although it's probably got the most number of bullet points to run through. Essentially, all you're looking to do is to either reduce the debt that's due to you or increase the value of the asset if necessary. And really, this is the point to make here. Really, is this is the point. It's at this point in time, that having a really experienced person on board when it comes to real estate recovery can add value. It can be a result of lots of different reasons, and that's why this section is a bit shorter, because there's a whole host of reasons. But the main types of things that I've been involved in more often than not that really do add those that added value is revolving around problematic tenants. So you're looking at doing your Section 8, Section 21s to get those tenants removed, or indeed putting new tenants in to add value to an asset. There can often be title issues, so if security is not being registered properly, if there's restrictive covenants, historic ones that might be causing issues, they can be removed, or restrictive covenants that can be problematic, we can look at resolving those. There might be access points on the title which can be difficult. There might be overriding interest that can be resolved. And practically, there's often things that we can do. So there might be management company issues, for example, on rental properties. There can be possible extensions to the property or build-outs that aren't done correctly. We've looked to change the use of status use of the property. Where there's been planning breaches unbeknown to the lender, we can look to resolve those. Sometimes, at this point in time, and I've put this at the bottom. It's not common, but it just to give you a demonstration of the wide variety of things that we've done in the past. You can consider appointing receivers behind the scenes, if you like, to get control of an asset, to get it into a really saleable position, in order that you can then continue working with the borrower in getting that asset sold. Because a receiver's appointment isn't necessarily public, then it isn't something that necessarily has to be made known to the markets. That can be really, really useful at times. So if we move on to dispose. Now, disposal, as I said before, typically is the last resort, but if you get no resolution, then obviously that's why you've taken security. Now, this part is much more formulaic and specific to the terms and conditions of your lending. That said, most security contains similar terms when it comes to recovery, so I'm going to run through these fairly formulaically. You do your formal demand if your initial letters haven't come to anything and you're at the point where you're going to have to take further steps. That almost certainly will be required under your terms and conditions of your charge, and more than likely your facility as well. Then you take some form of formal action. An appointment, typically when we're just dealing with real estate assets, of a receiver. The appointment of the receiver is a very straightforward process if you've not been involved in it before. Just means you get a property professional in charge of the property. It creates that buffer between the customer and the society. It enables you to have a real professional looking behind the scenes. And as I said just a few moments ago, that can be an almost invisible appointment, but it just lets the customer know what's going on. It means you've got a bit more control. It could be an IP, depending on your customer. It could be a corporate entity and you need to appoint administrators. Historically, it's not what I've done a lot of with the building societies, but again, if you need to, that opportunity is there to do that. I've put down on my notes just to mention that there are nuances with an appointment. That might be looking at things like agency relationships. They're detail that I can get into with you if you want to talk more about that. And the use of your power of sale sort of ties into my possession point. If you wanted to use your power of sale, you can get possession and sell, obviously using that. Again, it's nice sometimes to have the buffer of that receiver, so the receiver actually deals with the sale as agent, as though they were the borrower, which is helpful, I think, sometimes from the borrower's perspective. But yes, the use of your power of sale is often there. It's not necessarily a scary process, but that's something that the societies I've worked with in the past have typically not wanted to do. It's quite a draconian step, and I'm not going to use the phrase holding hands, but just doing it with this couple that I've done. It's not as scary a process it has to be, and it can be, if it's done the right way, can be a really positive step, and it can save some costs as well. So what can you appoint a receiver over? Just very, very briefly, fixed charge property. If you've got any debentures, which again isn't common for societies, but debentures secure all assets owned at the time the enforcement is taken, so long as they've been entered into properly. Now, the new aspect of the appointment point is that floating charge property can also now be used to be appointed over, which is a new rule for building societies introduced last year, which I'll come back to at the end of this presentation. Individuals and companies, so your customers might already be involved in a process, and this is where we look at the agency status. If they are, it doesn't stop you from taking action in respect of your outstanding debt. It might well mean that there's no agency relationship between any receivers that are appointed, which does have some implications, but 9 times out of 10, there's a practical solution to any issues that you might have. So if a company's been dissolved, for example, or a partnership, if a company's in administration, if an individual is in an IVA, if any individual has died, all those problems can be very easily resolved by the appointment of a receiver, which often is something which it isn't realised, but it's a really powerful tool if you've got any of those situations arising. Professional negligence is typically considered to be a last resort for a lot of people. It's always something worth bearing in mind. Just as an alternative if you are looking at a larger shortfall. Again, not as common with building societies, mainly because of your more conservative lending. So the last thing that we're going to look at is the floating charge appointments, which is the thing that's changed for building societies last year. Last June was when the Building Society's floating charges and other provisions ordered in 2016 came into effect. Now, what this allows is the building societies who have floating charges to appoint a receiver. It's not an administrative receiver, but it does allow you to appoint a receiver over property that you hold. Now, apologies if this is teaching anybody something they already know, but a floating charge can come into effect over the assets of the company in lots of different ways. So it might be an express floating charge over all of the assets a company owns, which again is typically done via debenture. It might be created though because a customer thinks he or she is creating a fixed charge, but the proper construction of that charge actually means it's floating. So there was a lot of case law about 10, 12, if not longer ago years about what constitutes a floating charge. So if it's an asset that is fluid, then it may well be deemed to be a floating charge, even though it's been created as a fixed charge. You typically don't get that where you're looking at real estate property, but appointments of receivers can be over all sorts of assets. So we had one corporate entity, for example, a few years back where they'd provided what they thought was a fixed charge over lots and lots of cranes. Well, they were cranes that they hired out, so they were often out of their control, even though they owned them. That was arguably a floating charge, but this piece of legislation would have really helped society in that case, because we could have been certain that we were still appointing in a correct way. Now, there are certain circumstances where a floating charge will crystallise into a fixed charge over particular assets. Sometimes that can happen automatically by the operation of common law. If, for example, there's a formal insolvency process or a company ceases to trade. Alternatively, there will be terms in the security which will allow the society to crystallise a floating charge. So, for example, giving notice that you are crystallising it, and typically that's default provision, so they fail to make a repayment or something like that. But by the time you've got to thinking about can I make a floating charge appointment, you almost certainly will have the ability to do so by virtue of some form of default. Once that floating charge has been crystallised into a fixed charge, then you can appoint a receiver in exactly the same way as we do under any other fixed charge security, which is an absolutely fantastic thing for building societies, because it really gives you potentially a much wider remit to recover assets. So I'll talk very briefly about those things. The only other comment I want to make, which I think is sometimes useful and sometimes forgotten, is that you can always add the cost of any aspects of recovery to the outstanding debt of a customer. The only thing to consider, as I mentioned earlier, is obviously if there's a shortfall, then that increases the debt, and that's maybe that will be a cost the society has to bear. There also might be commercial reasons why you wouldn't want the borrower to bear the cost of recoveries, and that does happen at times. The best thing about the way I work now is that everything I do is on a fixed fee, so you've always got that price certainty from the start, which is absolutely brilliant. Just finally, I've done a couple of it's a single slide on the synergies that I think I can now offer working at gunnercooke. I'm not going to run through them, they're there for you to have a look at. It's a really super position I'm finding myself in. I really would love to work with more building societies as time goes on. If you've got any questions, then please do drop me a line. My contact details are at the beginning and the end of this webinar. Give me a phone call, drop me an email, and I really do hope that I get to work with some of you going forward. As I said at the start, if you've got any questions about anything, I'm conscious it's been a whirlwind tour through the recovery process. If you've got any questions at all, drop them on a line. I'd love to chat to you. Something I'm very passionate about, and I'm really pleased that I get to carry on where I left off of my career. So I'll leave it there. If you've got any questions to say, please do drop me a line, and look forward to speaking to you soon. Thanks.